Alrighty, everybody. Thank you so much for tuning in to Behind the Defense. I am your host, Matt Wayman of the Hammer Law Firm. Here with me today is Zach Nunn. Zach is a public defender in the city of St. Louis. Zach graduated from St. Louis University School of Law after earning a degree in political science from Southern Illinois University of Edwardsville. He began his legal career as an intern at the public defender's office in the city of St. Louis and is now a full-time public defender for just over a year. In his free time, he enjoys spending quality time with his partner and performing stand-up comedy, which is how we actually met for the first time. Zach, thanks so much for being here today.
Yeah, thanks for having me, Matt. I appreciate it.
I thought of you immediately when I was getting ready to start the podcast up again about talking about kind of how criminal cases are instituted. You are a public defender, so you get to kind of see cases from the start. So I guess just my first question to you would be, how do criminal cases generally start?
Yeah, so generally the police get a phone call, a 911 call usually. The police come out, will investigate what happened, talk to witnesses. They write a police report, usually make an arrest at the scene. Other times there's, an anonymous tip or something. But usually I think from what we see is, the police get called out, they make a report, get people's sides of the story and make an arrest. They then take that arrest and that police report to the prosecutor's office in whatever jurisdiction they are at and speak with the prosecutor about what happened. And then the prosecutor looks at the police report, talks to the cop, matches that up with what the law in that state says, and then decides what charges, if any, to file.
I think a lot of people assume that the cops actually charge cases. Are the police actually the ones that charge the cases? Because that's not what you said right there.
Right, yeah, no, so the police do not actually charge the cases. They will make arrests if, if they have probable cause or if they have a search warrant, they can arrest someone. But they then must take that information to the prosecutor's office. And the prosecutor's office is the people that decide if charges, if any, are going to be filed.
Right. And then they will compare those charges or the information that they gain during the course of their investigation to the actual criminal statutes. And they'll decide whether or not they believe that they can prove somebody guilty beyond a reasonable doubt. Right?
Exactly.
Okay. If they don't arrest somebody at the scene, how long can these investigations take?
Yeah, I mean, I think they can take a while. I think usually, I don't know what your experience is, but I feel like usually you see the standard, they come out, make an arrest there. But there are some cases, that, they're investigating for something for a year, sometimes longer, trying to build up a case against someone essentially until they get enough probable cause to arrest someone or get a search warrant sometimes. So sometimes it can take a really long time to build this investigation.
Yeah, in the state cases, we do see quicker investigations. Obviously, in the city where they are hurting for police officers, the investigations are usually done a bit quicker. Mm-hmm. But on the federal side, for example, I mean, these investigations will last 2, 3, 4 years. By the time you get arrested on a federal case, it's likely that they have baby pictures of you. So they have those cases take a very, very long time. I guess an investigation could take anywhere from 5 minutes all the way up to 5 or 6 years. So the prosecutor institutes a criminal case. So they're the one that charges the case. What happens after that case is charged?
So once a case is charged, if someone is already in custody, if they're not in custody, they will issue either a warrant or a summons for a court date. If they are in custody, the case will be filed. It'll be a criminal case. It'll be online. People can see it. And they will get a court date. Missouri, at least, especially in St. Louis, which is the only place I practice, you get a determination of your bond if you're arrested after 48 hours, and then also another one after 7 days. So once they file the charges, it kind of starts up the whole court process of getting court dates and going from there.
And I guess just for people that don't know, what is a summons?
So a summons, I actually don't see them much in the city of St. Louis. I think usually most cases are issued with an arrest warrant. But a summons is essentially they file a criminal case and then would mail something to wherever the defendant's address is saying, hey, you have this case against you. Here's a court date that you must appear at. So essentially giving them a chance to come to court themselves without actually being arrested on.
And if they don't appear, then usually a warrant would be issued after they fail to appear a number of times. But you're right that they don't do that in the city. And in regards to the bond determination, the original bond hearing and the 7-day hearing, that's also kind of something unique to the city of St. Louis, right?
Yeah. So the 2-day and the 7-day is unique to the city of St. Louis. As far as I know, I mean, you might have more experience practicing outside of the city of St. Louis. But I know it's something we do here where after 48 hours of your arrest, you're going to see a judge. And the judge is going to decide at that point if you're going to remain confined or if you're going to be released on bond. And then if that's denied, if you're held confined after 7 days, you'll get another one of those hearings.
Yeah, it is. And generally in the county or in a lot of other counties, smaller jurisdictions, there's the Victims' Rights Act, and there's notice requirements. So if it's a victim case, generally you're going to wait at least 5 days in order for you to be heard on the issue of bond. And that's after your attorney files the motion. So you don't just get a hearing like you do in the city. So I would say that for the city, that is somewhat innovative and somewhat helpful for people that are taken into custody in the city of St. Louis, if they are then allowed to be heard on the issue of bond and actually given a bond. So once the cases get charged and the warrant and the person gets taken into custody, we're talking about a bond hearing. And what generally happens at a bond hearing?
So at a bond hearing, the judge is going to hear from the state of Missouri through the assistant circuit attorney or a prosecutor, and then also hear from the defense attorney for the defendant. And what the judge is mainly considering is this person going to be a danger to the community or a danger to any victim? And then are they a risk of flight? Are they going to come back to court, essentially? So both sides make arguments. The state is often arguing that someone is a danger to the community and that they won't come back to court. And the defense is often arguing that they are not a danger to the community. They'll come back to court. And that, usually you're talking about what is the least restrictive mean, which is what the law says in Missouri. What is the least restrictive means to ensure that safety of the community and that the person comes back to court? So those are kind of things the judges are considering, and the defense attorney and the prosecutor are kind of arguing both sides of that.
Yeah, two things always come up in a bond hearing, and you're right. It's public safety risk and flight risk. That's what I tell absolutely everybody. What types of things do judges take into account when they're determining as far as public safety risk?
Yeah, I mean, I think they do look at people's prior convictions, what kind of criminal history they have. They do look at the charges before them of the case that's actually in front of them. And then they look at, how long has this person lived in the community? How old are they? Like I said, what kind of history they have. And then usually the prosecutor will bring up if there's any specific dangers to a victim, if it's a victim case. But those are generally the things I can think of that a judge is going to be looking for.
Yeah, that's right. Criminal history is probably a big one. And then the nature and circumstances surrounding the crime that the person is accused of. There's a probable cause statement that's filed with these cases, and the prosecutors and the judge and the defense attorneys have access to that probable cause statement. And a lot of times it does come down to the nature and circumstances surrounding the crime and also the person's prior criminal history. In the city of St. Louis, are they doing a lot of cash bonds anymore?
No, I mean, it might be different from since I'm a public defender, but I don't think they really do much cash bonds. I've seen some, private attorneys, even some people who have public defenders that have a lower cash bond. I think compared to other jurisdictions, my guess would be it's a very low amount of the bonds here are cash bonds.
It is. It's more similar to Illinois rules where they're not really doing cash bonds. When a case does get instituted in associate and also circuit court, you're also entitled to an arraignment. What is an arraignment?
Yeah, so the cases, if it's a felony, it starts in the associate court, which I was explaining is the lower level court where the felony cases start at. In order to get to the circuit court, which is the higher court, that's where pleas and trials, all the fun stuff happens. Has to be a finding of probable cause. And there's two ways to do that. They can have a preliminary hearing, which I'm sure we'll talk about, or seek an indictment from the grand jury. Let's say, for example, someone's been indicted, a grand jury has found probable cause for the case to keep going forward and go up to the circuit court. You'll do something called an arraignment, which is where the person is informed of what the charges are against them. And usually if they have a defense attorney, we talk to them about what the charges are, explain everything to them. And then that way in court, we can waive a formal reading of the charges and not kind of waste everyone's time if everyone knows what the charges are anyway. So usually what it practically looks like is you waive a formal reading of the charges and then enter a plea of not guilty. And then it gets transferred up to that circuit court where you can work out a plea or a trial or file more substantive motions.
Yeah, I always tell my clients that the only time that you'd want an arraignment is if you're arrested on a Friday, we get to Monday, and you don't even know what you're being charged with. If nobody tells you what you're being charged with, then you would want an arraignment because you don't know why you're being held. But by the time they get to attorneys like us and you're like myself and you, they generally 99.9% of the time already are aware of the nature of the charges against them, which is why we waive formal reading the indictment and enter a plea of not guilty. You would really only ever enter a plea of guilt, I guess, in circuit court if you had some sort of disposition already worked out by arraignment time, and then you're pleading at that point.
Right. It's like when you see cases in the news and, people are freaking out because someone entered a plea of not guilty at the beginning of a case, but practically speaking, that's really the only option at the beginning of
Yes.
the case. So,
You would never, you can't enter a plea of guilt
right.
at the associate circuit court level.
Mm,
And once you get to circuit court, some jurisdictions like Jefferson County, for example, they'll give you an offer down in associate
mhm.
circuit court. And then you could accept it at your arraignment once it gets to circuit court, but that's a very rare circumstance. We were talking about preliminary hearings and a grand jury. What is a preliminary hearing and what occurs?
So a preliminary hearing is also called a probable cause hearing. It's usually just witnesses, defense attorney, the defendant, obviously, and the prosecutor, and then the judge overseeing it. And the point of the hearing is to determine if there is enough probable cause for the case to be bound over to that circuit court. They're not deciding if someone is guilty or not. They're deciding if there's enough probable cause for the case to keep going forward. Usually, what happens, I know other jurisdictions have a lot of, there's lay witnesses, there's civilians that testify. At least in the city of St. Louis, it's almost always a police officer will testify as to kind of their investigation, what happened. Prosecutor does a direct examination. Defense attorneys like us get to cross-examine them, and then the judge decides if there's enough probable cause for the case to keep going up to the circuit court.
Yeah, it's a low bar. I always tell my clients 51% over 49%. I mean, generally, it's like a free deposition, right? I mean, you
Mhm.
get a chance to question the law enforcement officer about what they did or did not do during the course of their investigation. But generally, if people show up, there's a pretty good chance that it's going to get bound over. But we
Yeah.
also do sometimes win cases at preliminary hearings. What type of cases can you win at a preliminary hearing?
Yeah, I think it's important to identify like an issue that's going to be kind of like at issue. If it's a search, I've seen some where it's just a blatant, bad search by the cop. They violated someone's rights. And sometimes judges will say, that's an issue for circuit court. But I have seen judges say, I don't think this evidence was obtained legally, so I'm going to dismiss the case. I've also seen smaller things where they forget to identify the defendant, kind of like in TV, there's always something like, is that the person that you arrested? And the judge says, let the record state that the defendant has been identified. If they forget to do that and no one points the finger at the defendant, then the case should be dismissed. And I've seen that happen. So there's a wide array of things. I think in my experience, it is rare to win
Sure.
a case at a preliminary hearing, but it does happen.
Yeah, valuation sometimes on like stealing
Mhm.
cases if nobody's going to be able to lay the foundation as to how much that stuff was worth. I won one yesterday over in the county because they had the wrong victim show up. They didn't realize it was a different victim. They brought somebody from like a shipping company when really the victim was the person that was getting the item shipped to them, and
Oh,
they didn't bring in the actual victim. And if you don't have a victim, then nobody was there to say that anything was stolen. So that case actually got dismissed, but it was absolutely rare. And even if it does get dismissed at preliminary hearing, does that mean the case is gone forever?
no. So if it's dismissed at a preliminary hearing, it's dismissed without prejudice, which means that it does not bar the state from refiling the charges. And that does happen sometimes where a case gets dismissed for, something small like that, and the state will turn around and then refile the charges. So you always tell people like, hey, this is dismissed for now, but it's without prejudice, and that could change.
Yes, within the statute of limitations. I mean, what you would hope for is like they don't issue a case for 2.5 years and then you get it tossed at a preliminary hearing and then they don't reissue within 6 months. But
Right.
yeah, they do have 3 years on felonies and a year for misdemeanors is the general statute of limitations, subject to exceptions, obviously. So then if the preliminary hearing is one way, what is the grand jury?
So the grand jury is another way that the state can find probable cause for the case to keep going forward. If the state chooses to take a case to the grand jury, and that's another thing, is it is totally up to the state's discretion whether they take a case through a preliminary hearing or through a grand jury. A grand jury is kind of like a regular jury, except that instead of deciding if someone is guilty or not guilty, they are deciding if there's enough probable cause for the case to go to the circuit court, for the case to keep going. So it's essentially random people from the street, like a regular jury, that hear evidence. Unfortunately, unlike a trial, the defense attorney is not there. There's no cross examination. It's a one-sided thing. And then the grand jury decides if there's enough probable cause for the case to keep going.
Do you find in your experience that cases that you might be able to win at a preliminary hearing would get bound over by a grand jury?
Yeah, I think I do see that a lot. I think if a case is going to a grand jury, I think it most likely will be indicted. It seems like, in my experience at least. And there are some cases where you look at it and you're like, man, I wish I would have had a preliminary hearing on that. But it's up to the state. That's
Yeah, they do take a lot of cases, like any victims cases. Generally,
Mhm.
they'll take to a grand jury. Some of the stuff they let to go to PH in the city is like possession of a controlled substance or some sort of like stealing cases. But anything that they want to get over a grand jury or they want to be able to get to circuit court, that might make the news or something. From my experience, and stop me if your experience has been different, but they'll generally take it to a grand jury.
Yeah, like you said, Matt, I've been a public defender now for a little bit over a year, and I've never had a preliminary hearing with anyone other than a cop in the city of St. Louis. So I think that seems to be the policy that if it's a police officer and they can make the case through just a cop, they'll do a preliminary hearing. If they need a lay witness or something, it seems like they're going to take that case to the grand jury.
Yeah. And that's a long time. 1 year in public defender years is about 5 in
Right.
private attorney years. So you're
Hmm.
experienced at this point. They also do this thing in the city that they don't do in a lot of other jurisdictions. It's referred to as a wanted. Could you kind of just explain kind of what that is?
Yeah, so it's the police officers in St. Louis will, when they're investigating a case, they have options. You know, if they see something happen, if they have probable cause, they can arrest someone right there. If it's something more where they're investigating it, they're talking to witnesses, trying to build a case, they can get a search warrant or an arrest warrant from a judge, where a judge signs off and says there's probable cause. But I think what I see more often is they just do something internally called a wanted, where they will just put out, I don't know what the system is with the St. Louis Police Department, but they put out in their system, hey, this person is wanted for arrest. And then based on that, when another officer sees that person, they will take him into custody based on that wanted. So it's not a warrant, it's a wanted. So I don't think there's much like case law on it right now, but it is an interesting area of the law where they're not getting warrants, they're just getting wanteds to arrest people.
It's a very interesting issue, and there's a lot of concerns because, one, attorneys like ourselves have no access to the wanted database to be able to tell people that wanteds are out for them. Sometimes they will tell us on like lower level, like assault fours and things like that, assault in the fourth degree, which is a misdemeanor. Sometimes they'll tell us, but other times somebody will just be driving around for 2 or 3 years and then just get pulled over and they get picked up and then immediately taken in for question and booked. Can you enter a plea of guilt in associate circuit court?
On a felony, you cannot. They're not going to let you enter a plea of guilty. Usually that's something that happens at the circuit court. Misdemeanors, on the other hand, stay in the associate court. So that they will be in the associate court for the life of their case. So you can enter a plea of guilty in the associate court if it's just a misdemeanor.
And for misdemeanor cases, are you entitled to a jury trial?
You are not entitled to a jury trial on a misdemeanor. But my understanding of the law is that you can be told that you're doing a bench trial on a misdemeanor.
Yes, you can request a jury trial, and a lot of jurisdictions will give you.
And most will give it to you, right?
Yeah.
Like in my experience, I've never been told on a misdemeanor that I've requested a jury trial, you're not getting a jury trial. I think they would have the right to say that, but I've never been told no in St. Louis City, at least.
Generally, everybody will give you a jury trial
Right.
on a misdemeanor, but yeah, the rules are a bit different. And then my last question to you would be, you have been at the public defender's office for a year. It is a stressful position. What advice would you have for somebody that's thinking about getting into public defense work?
I think if you're thinking about doing it, I would first say do it. I mean, it's obviously very stressful, high caseloads, but it is the best job that I've ever had. It's the only legal job I've ever had, but it's by far the best job I ever had. I feel like I make a direct impact in people's lives, but the way I'd learned that I wanted to do it is by doing internships. I went to law school, and after my first year, I did an internship. And then after my second year, I did an internship. And after a couple of years of interning, I was like, this is for me. So I think if it's something that you're interested in, call a local public defender's office and ask if you can job shadow or just intern. I mean, I don't know of any public defender's office that's going to turn down someone offering to help. And I think that's the best way to do it, is just roll your sleeves up and get involved, and help out in any way you can, and just kind of talk to some people that are doing it and see if it's something that you would like. But I know a lot of people talk about the stresses of it, and that's definitely there, but it's also incredibly rewarding. So I would just say, call an office near you and get involved and try to help out.
Yeah, that's one of the cooler parts about the legal profession. I mean, there's a lot of negatives, but one of, I think, the positives of this profession would be that you really can reach out to any attorney and say, hey, I got this question for you. And 9 times out of 10, they will actually answer that question, which a lot of
Definitely.
it doesn't happen in a lot of other professions. Did you know right away after you were doing the job for a little bit that that's something that you saw yourself doing?
Yeah, so I kind of decided late on going to law school. I didn't decide until like the very end of my senior year of undergrad at SIUE. And I started like tossing around the idea of going to law school and, reading like criminal justice books. And the idea of being a public defender was very interesting to me. And then I wanted to take a year off between college and law school. And I did a sales job. 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 And I and I just hated it. I was like, I need to do something that I like actually care about, that I feel like I'm actually making a difference in. So that was kind of my sign to actually go forward with law school. And then I did, an internship and another internship, and both of those kind of confirmed that this is what I wanted to do. And now, even a year in, stresses and everything aside, I'm very happy with the decision. I think it's a great job. Honestly, I'm having a blast. So
You work at a good office. There's a lot of very talented attorneys at your office that are just fantastic
yeah,
individuals as well. Your boss is unbelievable as well, and just
yes, best boss I've ever had.
such a great guy, so personable, and just very much cares about his employees, but also the population of people that you guys are serving. The last thing I want to chat with you about is we actually met doing stand up comedy, which I think is a good correlation to jury trials. I mean, that's kind of what got me into it. I wanted to kind of take my performing skills and move them over to the legal side. I was also passionate about criminal justice, which is why I'm here now. But can you kind of just explain how you got into stand up and kind of how it plays into your job?
Yeah, I mean, I've always been interested in stand up. I've always watched it, and I've always had the idea that I would do it. It got more like I considered it more and more, and then I was studying for the bar actually, and I was like just driving myself crazy, spending all day studying. I was like, I need to like do something different at the end of a day that is going to make me think differently. And I think of it the same way now, is that like, stand up makes you think differently than like law does. So it's a good like reset of the brain. So that's originally why I did it, to get a break from just like legal thinking all the time. But I think it has been super helpful. I mean, the obvious just confidence of every day in court. I know, a lot of lawyers aren't always in court, but I'm in court almost every day. I think if you can get on a stage for 4 minutes in front of a bunch of strangers and try to make them laugh is incredibly vulnerable. So I think that's made it a lot easier to get in front of a judge and argue something, get in front of a jury and try to convince them. And I think it is similar, like you said, Matt. I think, if you're trying to convince a jury to side with your side of the story, it's very much like getting people to laugh, because you're trying to get them to kind of come along with you in this journey. And so I think it's very similar. It's been very helpful as far as the legal field.
Yeah. And the first thing I would say about that is that 4 minutes is an incredibly long time.
Yeah.
Like, a lot of people
Yeah.
do not realize how long actually 4 minutes is until you have a microphone in your hand and a bunch of people are staring at you. It seems like forever. But you're right that it does give you these skills, improv skills, that where you like people do yell out things when you're performing stand up, and you have to kind of come right back at them. And then also thinking on your feet and just being in the moment, I think, is one of the most powerful things.
I don't know. I haven't done it in a while. I want to get back to it eventually. I think it's been tough with like, I come home every day and I'm like, oh, I'm tired. And it's like, but every time I go and do it, I was telling my girlfriend this, like every time I go and do it, I immediately feel better. I'm like, oh, I'm glad that I did that. So I do want to start getting back in. It's been a bit, but I want to get back into it for sure.
Every couple months, my wife will be like, you need to do stand up. Like, I try to do it like at least once a week, but there'll be some times where it just weighs on you. It's like, this is what you need to do, is go do some stand up.
For sure.
You had the disadvantage of being funny right away. And a lot of people, it takes a while. Like, it took me years and years to get funny. And you were pretty darn funny right away, which I've always argued is a disadvantage, because you realize, you're like, well, this is easy. I don't have to grind it out. So that's just a benefit to you, that you understand joke structure and how to write jokes from the start, which takes a lot of people.
I appreciate that. It didn't feel easy on stage, but no, I do appreciate that. And it's like, I've definitely had my share of time on stage where like no one laughs. And so the times where a lot of people do laugh, it does kind of get you right back into it. So I'm glad I'm a little bit funny.
Zach, if they want to catch you on stage in St. Louis, is there anywhere that people can find you?
I go to Steve's Hot Dogs. I need to get back out there. That's kind of the place I go to. I think that's the place we met at doing stand-up, but maybe go out there on an open mic night and have a hot dog. Yeah,
they do an open mic every Thursday. Steve's Hot Dog, Steve's Hot Dogs down there on Grand. I'm also running a new showcase. I'll book you on that showcase too, so we can get you out in front of some more people.
Let's do it, yeah.
Guys, thank you all so much for tuning in. We're going to be back soon with more podcasts. This has been Behind the Defense.